हेलो फ्रेंड्स। इस वीडियो में हम बात करेंगे एक लेटेस्ट जजमेंट आई है ऑनरेबल बॉम्बे हाई कोर्ट की रिगार्डिंग द इंटरमीडियरी सर्विसेज इन जीएसटी। फ्रेंड्स, इंटरमीडियरी सर्विसेज were also there in the service tax regime before introduction of GST. So this subject has always been in litigation and in dispute, and in GST again the dispute is coming on the issue of taxability of intermediary transactions, and whether they are export of services or not is a big question. So recently a case was filed in Bombay High Court wherein the honorable two judges gave difference of opinion on the issue of constitutional validity of section 13(8)(b) of the IGST Act. One of the judges said that the provision is valid intra-virus. The another judge said that the provision is ultra-virus. So the matter was referred to the Honorable Chief Justice of Bombay High Court, and then the third judge was given the task to analyze the judgment and give his opinion. So now we are decoding the judgment, the detailed judgment, the beautiful judgment given by the third judge, Honorable G.S. Kulkarni, the justice. So what is the summary, what are the synopsis of this judgment? We will talk about that. The judgment is quite lengthy and very insightful, and the judgment in its conclusion part is saying that 13(8)(b) in the IGST Act particularly is a valid and a constitutional provision. The second observation of the honorable judge is that though the provision is valid, but since 13(8)(b) is saying that the place of supply for intermediary transaction shall be the location of supplier, and the place of supply and the location of supply shall lie in the same state, therefore that 13(8)(b) cannot be made applicable to the Central GST and the Maharashtra GST Act. This was the critical observation. So 13(8)(b) is only limited and confined to the IGST Act only. The honorable judge said that if the IGST Act is being made applicable to the Maharashtra GST Act, it is again clearly the central act, that is integrated act, is legislating in respect to the Central GST and the Maharashtra GST Act. This was the critical observation, and this is a very deep, insightful of the judgment. So now what is the conclusion before us after going through the judgment? So the judgment is saying that we are not declaring the provisions to be ultra virus, we are not striking down the provisions, but the applicability of said provision to the Central Act and the Maharashtra GST Act is a big question. This was the key observation. So before this judgment, most of the intermediaries were paying Central GST and the state GST for the intermediary transactions. Now what will happen going forward, whether after this judgment they need to get the refund of the wrong taxes paid and pay the correct taxes, that will be a big question, and it will be deliberated in detail by Honorable Supreme Court, because the matter will definitely go to the Supreme Court for its decision. So this was all about this controversy. though we can discuss in detail or for you can say hours, but this will be a short video. I hope you like this video. Thank you very much for sparing time. Have a nice day. Thank you.